Hey everybody, welcome back to the channel. Today we are circling back to the California data breach by the Attorney General's office. We've had a lot of comments coming in, so we have asked for a little bit of Chuck Michel's time to kind of shed some light on these questions. Let's break into it. So Chuck, I think it's time to circle back here a little bit. I know that a lot's been going on, but we do still have a lot of questions coming in on the DOJ data breach. So I just kind of want to run through some of these questions that we're continuing to get here at CRPA, starting off with kind of the basic here. There's just a lot of people out there don't even know if their information was put out onto the internet. So where exactly can they go to see whether or not their data was leaked?
Well, unfortunately, there's not really a place where they can find that out. But they should, if your data was leaked, if you were on the list, you should have gotten a letter from the California Attorney General's office telling you so. The law requires anybody who leaks, and this is a leak, not a breach. This wasn't hackers. This was the DOJ, which is the custodian of this information, leaking it through this portal that they set up to share information about guns with the general public. And rather than keeping private information private, they went too far and leaked out the home addresses of folks. But the statutes require that the DOJ or anyone else who leaks information provide notice to the people who might be victimized by that. So if you were on this list, you should have gotten a letter from the Attorney General telling you that your data was leaked. And then they were so kind as to offer a credit monitoring service to make sure that your identity isn't stolen, which is completely besides the point. That's not the problem here.
Yeah, I definitely want to circle back around to that. You mentioned the addresses. Was that the only information that was leaked? And also, you know, CCW holders, was it also applicants for CCWs? What information exactly was leaked, and who was it that had their info leaked?
Good question. We don't know the precise answer to that, but we will be posting that on the page where this video is going to be posted as soon as we figure out exactly what was leaked. We know that the one that's gotten all the headlines is 200,000 CCW holders up till 2021 with their home addresses. That includes judges, prosecutors, defense attorneys, people who were being stalked. Remember, in many of these counties where people got CCWs, the good cause requirement up until the Bruin decision came down just recently, the good cause requirements required some kind of a articulable threat, some kind like a stalker or a death threat or something. So these people are genuinely, a big percentage of the 200,000 people that were, the names and addresses were leaked for CCW holders, were in genuine, you know, they're vulnerable. They're genuinely vulnerable, not just to a general, you know, to crime in general, but to some specific thing. So all those people are now in danger, but we don't know. Also the data leak included gross information, but apparently not the names, assault weapon registration information, firearm safety certificate information, and something else that I believe there's something else. But the point is, we're still trying to get to the bottom of exactly what was leaked under each category of information, and it will be posted on the CRPA's information page and supplemented as we find out more.
Okay, and you know, since the dawn of the internet, there has been people kind of waiting in the winds to kind of do some nefarious things, especially as technology has gotten better. I know it doesn't take a long time for these people to do it, and they're constantly sitting there and waiting. But this is another question that we had. Exactly how long was the information online? I know that the Attorney General's office was talking to sheriffs about it not being online that long. I've heard mixed results. Do we have a definitive answer of how long it was actually online?
It's 12 hours, probably more like 24, before the Attorney General figured out what was going on and pulled down their entire portal. Okay. But in that time, who knows how many times it was downloaded. And by the way, that's something that the DOJ should be able to determine. When things are downloaded, there's a record of that. The IP address or whatever is recorded. So they should know who downloaded this information, and I'm sure they will probably try and go get it back. Well, good luck with that. It's out on the dark web already. It's too late. The cat's out of the bag.
So what are groups like CRPA doing to help out these individuals? I know that we've seen local ordinances. I think particularly in LA, there was one that discriminated against NRA members. Here you essentially have a group of people who want to carry concealed. It's concealed for a reason, who have been outed to the community that can possibly discriminate against them. What are groups like CRPA able to do to help these people?
Okay, so what CRPA has been doing is trying to get all the facts and then share the facts with people who want to know them. We've been working with the Republican caucus up in Sacramento. Several of those members of that caucus have now demanded that the California auditor actually audit the DOJ, and they've done that a couple of times before and found that the DOJ was really screwing up all of its databases, not just the gun-related databases, criminal history databases, restraining order databases. I mean, the AG, there's some estimates that most of the databases that the DOJ holds have error rates up to 40%. So that just shows you how bad the government is at maintaining data and then securing it. CRPA is working with our advocates in Sacramento are working with the Republican Party to push for that audit. The DOJ, at the behest, we've been working with the sheriffs, all the sheriffs who issued these CCWs, and are absolutely furious that the private information of their constituents was now leaked by the DOJ's through its own incompetence, and they're insisting on an independent investigation. And the Attorney General's office has hired the law firm of Morrison and Forrester to do an independent investigation, so-called independent. That law firm is definitely a darling of the Democratic Party, but still, they have an obligation to try and get to the bottom of things and figure out exactly what happened and why. So we're working with the sheriffs to make sure that we keep the heat on that. And then mostly what we've been doing is communicating with people. 200,000 people, we've probably gotten close to 10,000 emails and inquiries about this. People want to know what's going on, what can they do? And we're putting together sort of a menu along with the information page where we're collecting all the media coverage and results of any investigations and what we know. We're collecting it all on that information page. And then we're trying to come up with a list of options for folks, because everybody wants to know, what can I do? Can I sue them? What can I get if I do sue them? And how can we hold them accountable, even if you can't sue them? The Attorney General shouldn't be able to get away with this. So we have a petition to lobby Bonta to resign, and because of this incompetence. And if we get enough signatures on that, that actually may get some traction. But in the meantime, people want to know their legal options, and they have several. And we've been putting those together for folks. The one that everybody's talking about is a class action.
Yeah, so let's absolutely talk about this. I understand that there is a group that's already filed a class action lawsuit. Can we just kind of dispel, because class action lawsuits are a little bit different than the generic CRPA lawsuit that you would see like Duncan v. Becerra. So can you break down what a class action lawsuit or a mass action lawsuit actually is, and what's the process for filing? How exactly are these people represented?
So I want to tell everybody about what class actions are, what mass actions are, and what individual lawsuits could be. I've spent a lot of time trying to figure out which one of those options might be best and might get the best results. And I think it's going to vary by individual. I will note that one group out of Colorado that hasn't really been involved in California historically and hasn't been in this state to defend California gun owners really before, jumped out in front to file a Second Amendment class action, which frankly doesn't make a lot of sense to me. This isn't a Second Amendment claim. It's a privacy claim. The Second Amendment claim might be from those who wanted to apply for a CCW, but now they're being discouraged because they're afraid that their information might be released if they do get a CCW. And that's probably part of what Bonta intended, to scare people away, because it's now going to be a lot easier to get a CCW, at least because you don't have to establish the special need good cause that you're used to in some jurisdictions. But there's not a clear answer that it's not a one size fits all. The problem with this lawsuit, this privacy breach of privacy lawsuit, is that there's the doctrine of the legal doctrine of privacy rights is not all that developed. So what people have primarily been worried about when you had a leak of private information like this was their credit rating and identity theft. But in this case, it's a different class of damages, if you will, because what happens is people are now scared. It's emotional distress. Their information is exposed, and they're afraid that they could now be targeted, either to have their guns stolen, or because whoever it was that was threatening them to begin with now knows where they live. So people are scared, and rightfully so. But the privacy laws are not really set up to specifically contemplate and compensate for that. So this is another thing that, frankly, we have not finished developing the legal theories yet, but it's going to be problematic because everybody's level of fear and the reasonableness of their fear may be different based on their individualized circumstances. So this class action has been filed. And the way a class action works is this. Law firms run to be the first one to file class action. And then unfortunately, this group immediately started fundraising off of it. Even though when you file a class action, if you're a law firm and you file a class action, you represent the class, you go through some pre-trial, some motions early on in the litigation process, then you have to get the class certified. Once the class is certified, then all the people in that class are represented by that law firm, unless you opt out. You have the option of opting out of the class. But at the end of that, unfortunately, with class actions, usually the class members get some kind of a coupon or a free credit, a year of credit monitoring, or something that really doesn't come anywhere near addressing the wrong that's been done to these people. And then the class action lawyers get millions of dollars in fees because that's part of the class action process. The people who represent the class can get the fees. So the conventional impression of class actions is that it's really brought for the benefit of the lawyers, not the individual class members. But in this case, these lawyers and the group that's behind this class action are still fundraising off that. So I don't really understand the logic of that one. There may be other class actions filed, and I want to make sure folks understand, I can communicate with members of the class until that class is certified, at which point you become a represented party unless you opt out. That should be a while before that happens. That's another thing that we're going to have to keep an eye on and post the information on the website about the status of that class action and what's happening. And when they go to certify the class, you'll have an option to opt out of the class and pursue a different remedy or no remedy. The other remedies are potentially a mass action where we would have 5,000 or 10,000 plaintiffs that are individual plaintiffs, maybe in groups. So judges, prosecutors, whatever other groups there may be, defense attorneys, people who were stalked, celebrities, all these different subclasses could create a mass action of a large number of people that were in the class. And you get to have more individualized damages there. You can advocate a lot more clearly on behalf of those members of that mass action. And what we're going to do later on is bring in a friend of mine who is a class and mass action specialist to talk more about these options and the pros and cons of each. Then the third option is, and this is frankly the way I'm leaning, is individual lawsuits. Because Gavin Newsom right now is gloating because he's very vindictive and a sore loser and doesn't like the fact that the Supreme Court gave us the right to carry in the Bruin case from a couple of weeks ago. And he is signing all kinds of laws that create a private right of action to enforce California's gun laws. What he's trying to do is let all the lawyers from every town basically deputize, all the people who hate gun owners, and give them the authority to sue manufacturers or retailers or whoever else without the state having to be involved. So this is part of the strategy that the gun ban lobby has been advocating for years, where they about 10, 15 years ago, they put together a bunch of municipalities to file lawsuits against the gun industry for the criminal misuse of their products, trying to come up with some real attenuated theory holding a manufacturer liable for what a criminal did with their product, even though they had no control over that. But now what they're trying to do is, it's basically the death of 1,000 cuts, because they want to have all these lawsuits filed by a lot of different people against the gun industry. Well, I think turnabout is fair play.
Can people personally take action on this? Like, what are the specific damages that could be brought to them? And if they're interested in taking this action and bringing a lawsuit themselves, how do they do it?
What we can do is, and CRPA is putting together a sort of a template how-to guide on how to file your own lawsuit, your individual lawsuit against the California Department of Justice for your information being leaked out. So we'll have a fill-in-the-blank complaint, a list of instructions on how to file it, the arguments that to make, and then just let people have that, give that out as a CRPA product, and hopefully folks will join CRPA and spend the $50 for a year's membership for all we're doing on this. It'd be much appreciated. And then you get all the other benefits as well. But then this package would be available that would show people how to file their own lawsuit if they want to. And I think that if we could get 10 or 20,000 people to file lawsuits, and it could be a small claim, which is very easy because small claims court can do up to $10,000 these days. Then that would be a more fitting tribute and payback to the DOJ for this massive breach of public trust. So those are the three options we have right now. We'll probably bring a test case, pick one of the people that have been in touch with us to see what kind of opposition the DOJ brings, so that we can anticipate that and include that in the template lawsuit package that we'll prepare. Because we do want to feel out the DOJ and what kind of claims they're going to make. What they're going to say, though, is this information wasn't private. First of all, that's the claim they're going to make, and so we have to get over this hurdle because some of it wasn't. Your name as a CCW holder and your city and county that you live in, that's not private information. That has been subject to Public Records Act requests for a long time. The case law is settled on that. But the street address has always been considered private. DOJ will argue that it's not. It's just been a courtesy that they didn't release that before. And then they will say, you have no damages unless, just because you're afraid, that's not compensable with finances. And this gets into a very sort of arcane area of the law about emotional distress when you're actually not, hurt in a conventional way, like a broken arm or something. It's all mental distress. And so we're looking at analogous areas in the law where people with that kind of mental distress have made a claim and gotten damages. And we'll package that all into the information that we send out about a template lawsuits. But I just ask folks, please be patient. Gavin Newsom is on the warpath. Bonta, frankly, did this, and it's taking a lot of our time, and we're happy to spend that time to help folks. But we're also trying to get all these lawsuits ready to challenge all the other dumb laws and unconstitutional laws that Newsom and his cronies in Sacramento are putting together to take away your Second Amendment rights. So please just be patient. Keep your eye on that information page. We will post more information there as we get it, and keep people up to speed. And another big point is, please don't email us once you email to register, basically as somebody who wants to be in our class action or our mass action, or get the information about your own lawsuit. Once we have your email address, we can get in touch with you, and you've probably gotten a couple emails from us announcing, for example, this video. But now we've turned on the comment section